What I'd like to start with is the main issue in this case, which is the question of duty and whether there is a common law duty in the state of Florida to preserve evidence. And clearly that was one of the questions that the trial court struggled with, but it's our opinion that the trial court struggled with it in part because the defense drafted the order that's at issue up on appeal and clearly, in our opinion, misconstrued the law and didn't properly follow the law that existed in Florida at the time. What I'd like to do is walk the court through some of that law and talk about that because it's important to look at what all of the DCAs has done. Obviously, for present purposes, we care most about this court's pronouncements on those issues, and I will get to the second district's announcements on those issues, but I think that we have to look at all of them so we see how it comes together. If we start with the 4th District, and I'm going to start with the 4th District because that's the case that is cited by the trial court in the order. The court cites the Royal Sun Alliance case as support for the proposition that there is no duty in Florida, common law duty, to preserve evidence. Now, the interesting thing about the 4th District's decisions in this regard is that they subsequently completely reversed themselves in 2 cases, in both Flagstar and American Hospitality. Now, these cases are not, you cannot reconcile these cases. When you look at American Hospitality clearly says there is a common law duty to preserve evidence. That is in direct conflict with Royal Sun Alliance. And they both rely, interestingly, on the Hagopian decision, and both of them say the exact opposite about what the Hagopian decision stands for. One says Hagopian was not intended to create a common law duty. The other says that it was. Now, when the trial court entered the order in this case, the 4th District's most recent pronouncements on this issue were Flagstar and American Hospitality. Yet because the defendants draft the order for the trial court, the only case that's referenced by them is Royal and Sun Alliance, which has clearly been reversed at a minimum by the 4th District. The other interesting thing about Flagstar and American Hospitality that I'd like the court to note is both of those decisions came out on the exact same day. They were both issued on June 1st, 2005 by different panels. But clearly, the 4th District was aware of those 2 decisions being issued on the same day, and those 2 decisions are in accord with one another. They are consistent with one another, and they are contrary to Royal and Sun Alliance. So even if we look at just the 4th DCA's pronouncements on this, which is apparently what the trial court did, the trial court clearly ignored 2 cases out of the 4th District which contradicted what the other case said. So if you just look at the 4th DCA case law, the order that's on appeal has to be reversed. But now let's look at the 2nd DCA case law, which is what, of course, the trial court should have been following. But as we all know, even if there's no pronouncement from this court on what a particular rule of law is, if there's a pronouncement from another DCA, that's binding as long as there's no conflict. And so we have those 2 cases from the 4th. I'm going to get to the 3rd and the 5th. But let's now go to this court's cases in the 2nd DCA. We have both the Townsend decision and the Osmolsky decision. And in our opinion, both of these cases support our position that there is a common law duty to preserve evidence if there is a reasonable anticipation of litigation, which is a heavily factual consideration. I mean, it talks about reasonable anticipation, which talks about what someone knew and when they knew it. So when you look at Townsend, Townsend is a case that is directly on point. In this case, there was a wooden safety railing that failed. And the plaintiff was injured when this wooden safety railing failed. The employer destroyed or discarded the wooden safety railing. The plaintiff wanted to have a products liability action, just like our plaintiff did here, against the company that had installed and manufactured the wooden safety railing. Summary judgment was entered in favor of the construction company, finding no duty, and this court reversed. That case is directly on point. The only issue there in that case was because the case against the was still ongoing, they actually said one of the elements of spoliation had not occurred yet. But the court clearly reversed the summary judgment and said that there was this cause of action. When we get to Osmolsky, Osmolsky is a different case because in Osmolsky, the plaintiff prevailed in the underlying action. In the underlying tort suit, the plaintiff prevailed. There actually never was a spoliation cause of action that was triggered because you actually have to lose in the underlying case first, which we did. Our plaintiff lost her claim against Toyota. A summary judgment was entered in Toyota's favor because we no longer have the vehicle to use in order to establish the product's liability action. So when you look at both of these cases, they clearly support the fact that there is a common law duty in Florida. To go even further, so we've now looked at the fourth, we've now looked at the second, we look at the third district. There's the Palmas decision out of the third district where they have a footnote. It's footnote 11 in the Palmas decision. They very clearly say there's a common law duty in Florida when there's a reasonable anticipation of litigation, and they cite a Nevada case that's directly on point. You then come forward in time to the fifth district's decision in Stimson. And here's what's interesting about the fifth district's decision in Stimson. Now, I will say to the court that it was decided after the trial court issued the order in this case, so the trial court did not have the benefit of that decision at the time. But the issue is, does this duty exist? And what does the fifth district say? They say it exists. And what cases do they cite? They say, see Palmas, which is the third district case I just mentioned to you. They say, see this court's decision in Osmolsky. And they say, see the fourth district's decision in American Hospitality. So this whole notion about whether or not there is a duty under this scenario is, in our opinion, very clear.
Well, but isn't really the issue here not so much whether there's a duty, but who owes it?
I think that, well, the who owes it question goes to really both defendants, because they both had possession of the vehicle. And keep in mind, Judge Kelly, that Copart only had possession of the vehicle because Nationwide had given them possession of the vehicle.
What if the fire had been at Baker's?
Well, then I don't think at that point, I mean, keep in mind how the car got to Baker's. It only got to Baker's because the investigating officers at the scene, they have a contract with Baker's. The county, I guess it is, has a contract.
So would you have a spoliation claim there?
That I don't know. I mean, I'd have to.
Why not?
I'd have to think about the analysis there, and I mean, I guess you probably could, although in that scenario, someone had to take possession of the vehicle. But this is completely different, Judge Kelly.
Well, but I'm thinking about this, and I'm wondering if the fire had been at Baker's, what would your argument be on spoliation? Who would be responsible for that?
Well, I think that they would have still been responsible. I mean, they're taking people's Baker's. I mean, they're taking people's property. A car is a valuable possession, and even in a state of even when it's been in an accident. I mean, many times if you've paid your entire car off and it's been in an accident, the value of the car may exceed the damage, and you may be entitled to recovery.
A spoliation claim, though. So
I understand.
Going to be liable for a spoliation claim if anything happens to a car that's that they tow to their lot after it's been wrecked?
But I think the point that we're missing is the reasonable anticipation of litigation. You know, it may be that the case against Baker's would fail on that prong. I'm not sure. I haven't analyzed that. But what we know for a fact is that in this case, both Nationwide Nationwide knew of the reasonable anticipation of litigation. We had a very... What facts support that?
Sure.
We had a relatively low impact case with a severe injury. This, and I'm going to walk you through.
Well, just a second. It's undisputed that the opposing driver's insurance company did not contest liability.
Correct. That's correct.
Doesn't that negate a reasonable anticipation of litigation finding?
No.
They weren't contesting responsibility.
No, Judge, because they were still going to potentially contest damages. I mean, that's why you have to see how important this is. We have a case in which a lady's leg was amputated just 3 weeks after this accident. So she is airlifted from the scene, taken to the hospital, while nationwide, the defendant driver's insurance company, keep in mind, this is not her own insurance company that took possession of her vehicle. This is the negligent defendant's insurance company, took possession of her vehicle. They write her letters. They tell her, we are safekeeping your property. They then say to her in these letters, we are sending your vehicle to the Vehicle Evaluation Center. It says in the letter, what is the Vehicle Evaluation Center? It is where we do an analysis and investigation of damages and losses in connection with your claim. So the fact of the matter is that they would have had, as a Fabre defense to this case, a defense that the seatbelt was defective and that that's what resulted in these extreme injuries. Because, I mean, we do have a lady's leg that's amputated as the result of a somewhat more minor car accident. So there's no question, even their own adjuster admitted that he realized there was a reasonable anticipation of litigation. He said that in his own deposition testimony, Judge Crenshaw. We have those quotes in our brief, where he says, as early as December 28th, I suspected that there could be litigation. And certainly by January 2nd, I knew that there was a reasonable likelihood of litigation. There's just no question but that they understood the significance of that. But even if we take a step back and we have this legal discussion over whether there's a common law duty to preserve evidence and whether or not there's a reasonable anticipation of litigation, we have voluntary undertaking in this case. And there is no question but that we have the facts to establish voluntary undertaking, which are completely omitted from the trial court's order below. We have a letter from the insurance company, from Nationwide, where they say to Mrs. Hill, while she's still in the hospital, while her leg is about to be amputated, the letter is dated January 8th. We know that her leg was amputated by January 11th. This is Nationwide writing to Mrs. Hill, quote, your vehicle is now in the process of being transported to our claims office for further inspection and evaluation. So there's nothing about this letter that's telling her, that her vehicle is anywhere that isn't safe and protected. They provide them with a list of frequently asked questions where it's explained what this Vehicle Evaluation Center is. And by the way, the Vehicle Evaluation Center, Judge Kelly, which sort of goes to what you were saying about who owes the duty, is Copart. That's who the Vehicle Evaluation Center is. That's Copart, which is where the vehicle was sent. So we have that letter. Then we have a letter dated February 29th. Now this is after the vehicle has been destroyed, because the fire occurs on January 20th. But what they say in this letter is critically important. And I'm quoting again. This is again from Nationwide to Mrs. Hill. This is found in the record at volume 10, page 1812. This is a critically important letter. Quote, this is to advise you that on March 12, 2008, Nationwide Insurance will no longer be responsible for the storage, safekeeping, or any charges that may be incurred or accumulated. And this is all in connection with her vehicle. The whole letter is talking about her vehicle. So the point of this letter is their perception of what they're doing with her vehicle. They are safekeeping and storing her vehicle, and they've taken it on themselves to do that. And this letter is certainly evidence of what their intent was with respect to holding a vehicle that didn't even belong to one of their insureds. So it's our position that on the duty issue, even if this court doesn't want to add to the universe of case law on spoliation of evidence with respect to the common law duty, that there is clearly an assumption of the duty in this case, at a minimum a question of fact about assumption of the duty, and whether or not that Nationwide voluntarily assumed to protect her vehicle. The trial court even admitted that there's a question of fact on consent and whether she gave her consent. And the defense and the trial court just try to act like, well, that's not a material issue of fact. Well, sure it is. It's a very material issue of fact. And it's particularly important on the voluntary assumption issue. So in our opinion, the court can conclude, because we think the case law supports it, that there's a common law duty for spoliation of evidence when there's a reasonable anticipation of litigation. Whether or not there was a reasonable anticipation of litigation may be a question of fact here. I mean, you know, we're all used to dealing with questions of duty as a matter of law because 9 times out of 10 it's a question of law. But there are those cases where it's a question of fact. And when you throw in reasonable anticipation of litigation, that's one of those scenarios where it can be a question of fact.
I just want to let you know you are at your 15 minutes. You don't have to stop.
Okay, I'll just wrap it up. I'll just a few other quick things. But even the Brody case, which is a case out of Illinois, I'd like the court to look at that on the issue of voluntary assumption, because it is directly on point. It is a case where an insurance company took a vehicle, the vehicle was destroyed, and the person had a products liability action. And even that court finds that there was a voluntary assumption of the duty when the insurance company took possession of the car. So we think that whichever way the court wants to resolve the matter, we have the 2 options, the common law route, but at a minimum, the voluntary assumption of the duty. I think that given the time, and since both defendants will be arguing, I would like to reserve the rest of my time for rebuttal.
How are y'all going to divide up your time?
Okay. Good morning. We're going to do 15 minutes and 5 minutes, but with the caveat that my client, I'm Helen Hauser, my client is Copart, and counsel for Nationwide has the same arguments over a number of things, but there are areas where we are separate, and so she will take the last 5 minutes. She will discuss the issue of no damages as well as her separate issues. I will primarily discuss the issues of duty.
Okay, so I'll let you know when you're getting to your 15 minutes then. Okay.
Thank you, Judge.
Sure.
Counsel here has done an excellent job of creating a claim of conflict where one really does not exist. First of all, you have to look at the facts of most of the cases in which they rely. There was a specific promise that the person who took custody of the evidence was going to preserve it for the benefit of the other party. That specific promise does not exist in this case, and particularly as to Copart, which never had any communication whatsoever with the plaintiff. The plaintiff never heard of us. And so let's talk about the voluntary undertaking doctrine first, because I think that's the easiest. In the cases upon which they rely, a party has undertaken to do a duty such as directing traffic, which it would not otherwise have had, and in reliance on that undertaking, people drove into the intersection and were injured. Or the other one is the airport construction, where an engineer designed a lightning protection system. The airport built it according to that design. It failed, and they have obviously relied upon that. The element of reliance is 100% missing in this case, because the plaintiff never made any effort to contact anybody, claims she never even heard of Copart, that she didn't pay attention to where her car was. So there was no reliance on these parties. And also you have to look at what is it they undertook to do. They undertook to dispose of the vehicle, and certainly Copart undertook to auction it on behalf of Nationwide. It never undertook to keep it in any kind of super secure facility. It's an open lot. their business is auctioning wrecked vehicles, and these
So
vehicles...
apparently it wasn't an evaluation center like the letter said?
Well, they took photographs.
Is that the
They're-
evaluation?
when they take in the
Okay.
when they take in the car, they have a set protocol that they take photographs and they inventory it and they give that information. But
Auto sell, or so
Evaluation center is a euphemism for salvage yard?
I think,
What I hear?
well, they take photographs and evaluate,
Okay.
but they send it to the carrier. The Copart does no evaluation. The carrier sometimes looks at the lot where it's first brought in, sometimes elsewhere, but no, we did not act as a evaluation center. The only thing, and the contract's in evidence in the case.
Okay.
The only thing that Copart does for Nationwide is pick up the vehicle so it stops incurring those horrible tow charges, and then when title's cleared, it auctions the vehicle. And it does not in any way ever undertake to preserve the vehicle in exactly the same condition that it was in so that it can be used for evidence. There was no notice to Copart whatsoever that there is going to be any kind of litigation in this case. Now, let's go back and think about what a spoliation claim is. And we filed yesterday a notice of supplemental authority just because we thought the quote in this case, Perez versus Ladove, was so helpful. And it says, the essential reason for a spoliation claim is its deterrent effect on miscreant defendants. Well, what you really are trying to prevent as a public policy matter is from a defendant of losing evidence that it knows is going to be important in litigation and will be harmful to it. And when this finally got into the jurisprudence in Florida, we looked at, well, how do you handle this? Is it a separate tort, or should it be a jury instruction? And the Martino versus Walmart case is a thoughtful way of dealing with it. We decided that in Florida, if it's the first party, it's going to be dealt with within the case. And most of the cases upon which plaintiff relies here, you will notice, are these first party cases where either an adverse instruction was given, or if it's an intentional spoliation, then even a presumption can be given. But nearly always it's an adverse inference instruction given because the party who was involved in the case and was aware that there was likely to be litigation then should probably not lose the evidence until the matter is settled. But even that is not an absolute duty, and I think this case dealt with it in the Osmulski case, where we said, and this was the party that was going to be involved in the litigation, and it did not preserve the security videotape. And the allegation was made, well, you know, you had a duty, and you disposed of this, and we want an adverse inference instruction. And actually, they called it intentional spoliation. I think they probably wanted a presumption. And they argued that because the store should have known that this was essential evidence, that they were entitled to this instruction. And this court said, no, even though the store knew that there was a claim with the insurance company, the store believed that that was going to be settled for the medical expenses, and they did not have specific notice that a lawsuit was going to be filed. And this court said that is not enough to create a duty to preserve evidence. A possibility of litigation, even where there's an insurance claim, is not enough, even on the party involved, to create the duty to preserve the evidence. It has to be more than a mere possibility, even on a first party situation. Now, let's look at it as in a third party cases. The third party is much further removed, and unless there is specific notification to the third party that it needs to preserve this, or there's a specific promise, as there were in the Brown and Miller cases, where the third party agreed to preserve it, specifically agreed, there is not a duty. And this court dealt with that also. It wasn't this court, sorry. The Silhan case deals with the third-party situation and explains that it is essentially impossible for everyone, even an insurance company, to hold on to every piece of potential evidence just because there is a possibility that litigation may arise sometime in the future. It is unreasonable to view the concept of duty on such a broad scale. The more prudent approach would be for a duty to arise when the possessor of the evidence is informed by the plaintiff that a lawsuit will be or is filed. And that is the reasonable rule for a third party. The Royal versus Sun Alliance, I guess, is our principal case that deals with this issue, and it's not in conflict with anybody. It's a third-party case where the third party might have guessed that there would be litigation, but it disposed of evidence in routine cleanup, and the court specifically said that there is no common law duty to preserve the evidence where there is a mere possibility, and you are not specifically informed that there is going to be litigation. And it actually talks about the Hagopian and Brinson cases, which were first-party cases, in which a duty was found, and it distinguishes them, just as this court distinguished Hagopian when it decided the Osmolsky case. Because in Hagopian, that was the exploding Coke bottle case, and Publix immediately did a report and refused to give it to the plaintiff on the basis that it was work product. So they were not just guessing there might be litigation. They declared that we know there's going to be litigation, and therefore we're creating work product. And at that point, when it disposed of the bottle subsequently, there's no question that Publix was on notice of the likelihood, not the mere possibility, of litigation. And also that was a situation where things don't normally explode without someone's negligence, either a product defect or someone mishandling it. And so they had much more reason to be aware that there was likely to be a lawsuit. In our case, we had a crash between two parties in which liability is admitted. Copart, of course, is not informed of any of this, but it has no reason to anticipate that in a routine crash where the damages to the vehicle are not that severe, that there's going to be a product liability case. No one said a peep about that. And in fact, the product liability case was a very, very long shot. If you look at what the evidence was in regard to a defect, the investigating officer did not find anything wrong with the seatbelt. It was a routine crash. The investigating officer did not ask Baker's Towing to put a hold on the vehicle. She testified she didn't see anything unusual about the situation whatsoever. And the plaintiff's so-called experts did basically nothing. An expert, Iannacone, testified that he didn't find evidence of a defect at all. He didn't find literature of a defect, and he was merely guessing that, well, gee, maybe if I had it, I might find something. But that's not enough to alert anybody that there's a duty to preserve, and it's certainly not enough to carry the duty that the plaintiff, the burden that the plaintiff has. Let's go again over some of the cases that plaintiffs discussed. American Hospitality, again, is a first-party case, not a third-party case. And if you look at the facts of that, there was more than a mere possibility of litigation. So that there's, and again, I think that with a first-party case, you might be public policy-wise more inclined to find a duty. A third-party case is a different animal, where you have an outsider who's not involved in the litigation, has no reason to expect to be involved in the litigation, and suddenly plaintiff wants to say you have a duty to preserve everything. Flagstar is a completely non-conclusive case. It doesn't explain why the Denny's had a duty to preserve evidence, but I think you can guess that because it was the subsidiary corporation that actually ran the restaurant, that it was probably on notice of the claim against its parent, and they were closely affiliated. So I wouldn't be surprised if that were the reason why it was found to have a duty. But the case doesn't tell us, and I don't think it's precedent for anything where that wasn't really the issue. The Townsend case absolutely doesn't even deal with the issue. The Townsend case was a question of whether workers' comp immunity will completely bar a spoliation case, and the court said no, but then specifically said, we express no opinion as to whether this complaint states a cause of action for spoliation. So it specifically does not decide what level of knowledge a third party would have to have in order to have a duty to preserve. However, the case that we filed as supplemental authority, the Perez versus LaDove, which is a similar situation in workers' comp, specifically says no, there is no duty unless the employer is notified that it needs to preserve the equipment that injured the party. That you can't just have a free-floating duty that without any notice that you have to preserve everything. And that really is, I think, correct public policy, and this court looked at that really in the Smolsky case. You have security video. Does every store have to preserve every security video just on the chance that someone who fell on that video is eventually going to sue? No, this is just not practical. It's not the realities of business. Well, let's look at our business. No salvage business could ever work. I mean, you couldn't have a junkyard, you couldn't have a tow yard, you couldn't have a metal recycling, because everything that shows up on your facility is damaged. So do you have to wait 4 years to see whether somebody might file a lawsuit in connection with that? That would be absurd. And of course the insurance companies have a big problem as well, because if they had to preserve every single piece of evidence, they couldn't repair your house after you've had an appliance fire, they couldn't repair your car after you've had an accident because someone might want to make a product liability claim. That's just not reasonable in the public marketplace. So the reasonable rule is where you are notified that there is going to be a claim, then you may have a duty, or at least if you can't, like in our case, we really don't have the facilities to preserve something for evidence. It's an open lot. If we were notified, then we would write back and say, can't do that, you need to pick up the car, which is, in fact, is what eventually happened, that the plaintiff did pick up the car and kept it themselves. But at least we would have the chance to respond and say, here it is, you need to come and protect it. But to hold us to a free-form duty that every car that shows up on that lot needs to be preserved for 4 years, or maybe 12 if it's a product liability claim, would completely ignore the realities of business and how
You're at 15.
Okay, thank you. We also just want to point out that the product liability case said that she couldn't prove her claim because there was because the evidence, if any existed, had been destroyed. But even the federal court never found there was any evidence of a defect.
I think that was another state, wasn't that Judge Hayes in the state court? Yeah, I'm sure he'd like to be a federal judge, but it hadn't happened yet. Fortunately, I've known Judge Hayes longer than you, so I don't think he'll be too insulted if that gets back to him.
Right.
But
I promoted him, sorry.
well, I'm sure he was delighted.
Good morning, Hinda Klein here on behalf of Nationwide. I'm just going to very briefly touch on the issue of duty. My co-counsel has addressed all of the case law, and I'm only going to address those issues that are particular to Nationwide. I think the court in this case clearly was correct in granting summary judgment, finding that Nationwide had no legal duty to preserve the vehicle in question. There was no promise on the part of Nationwide to preserve that vehicle and no knowledge of a potential products liability claim at any time before the vehicle was destroyed in the fire at Copart. Now, opposing counsel has mentioned a letter in early January in which it was a form letter in which Nationwide informed Hill that her car would be taken to some kind of facility, which, as it turns out, there is no such facility. It was actually sent, the assignment to take the car was sent to Copart. But at no point in that letter is there any language that could be deemed to be some kind of an assumption of a duty to preserve it forever. There's no indication in this record that Ms. Hill ever actually received the letter, that she relied on that letter, and since it didn't specifically say we're assuming a duty to preserve it, you can't read that into the letter at all. And that's especially true because at no point in time, up until the time that Mr. Sanfilippo contacted Nationwide, well after the destruction of the car, was there any communication between Hill, a member of her family, or a representative, and Nationwide, except for a request on the part of her first counsel for policy limits and a copy of the policy. That was the only communication. So there's no evidence in this record that Nationwide ever assumed a duty to preserve the evidence, and as the trial court correctly found, if it could be said, and I don't believe that this is a fair reading of the evidence, but even assuming that there was some evidence that Nationwide improperly exercised some manner of control over the vehicle, that doesn't translate into a promise to preserve that vehicle as evidence in perpetuity. Now, in this case, the evidence is that Nationwide did not physically ever have possession or control of the vehicle. What it did was it sent a request to Copart to obtain the vehicle from Baker's, assuming that Copart could not have obtained that vehicle from Baker's unless and until Hill or a member of her family released it. Baker's is under a legal duty under Florida law not to release that vehicle without the consent of the owner. I think Mr. Baker testified that he did have the consent, and Ms. Hill's daughter said that he didn't, but the fact remains no one could have exercised any dominion and control over the vehicle unless Baker's had released it on the at least assumption that the vehicle had been released to a third party. So there's no evidence in this record to sustain the claim that Nationwide had a legal duty as a matter of law, knowing that there was any potential litigation, nor is there any evidence in this record that Nationwide assumed this legal duty. In the Osmolsky case, this court was very clear in saying that we hold that if a defendant has knowledge that an accident or incident has occurred on his property and the same defendant has a video that may have recorded the accident or incident, defendant has a duty to obtain and preserve a copy of any relevant information recorded by the camera if there is a written request to do so has been made by the injured party or their representative before the point at which the information is lost. There was never any request from Nationwide, Copart, or anyone by any representative of Ms. Hill to preserve this property before the time of the fire, and therefore the court was absolutely correct in finding there was no legal duty. On the second issue, I think the court understands, based on Judge Crenshaw's case, that there is no evidence in this record to establish that Ms. Hill's claim was impaired as a result of spoliation. Nationwide made a policy limits offer to settle this case on behalf of its insured very early in this litigation. There is no evidence that the plaintiff could not have ever proven a case against Ms. Hill, and she ultimately, Ms. Tipton, and she ultimately did accept those policy limits. So there is no evidence in this case that any claim was impaired as a result of the destruction of the vehicle. The products liability claim is completely hypothetical. There's no evidence fact-wise or expert testimony-wise to establish that the car would have had any evidence relevant to a product's liability case. And you can't simply say that because the evidence no longer exists, there must have been, that must have been the cause of the inability to prove a product's case. But the bottom line is, since the claim against Ms. Tipton was never impaired, and Ms. Hill could have received her damages from Ms. Tipton, at no point in time could Hill have demonstrated that there was any causal connection between the destruction of the vehicle and her inability to recover any of her damages. Thank you.
Counsel. Thank you.
Just so that we're clear, because, I mean, we need appellate courts to resolve things that parties don't agree on, but this is not my statement of the law. This is the court. This is, for example, I'm going to start with as Osmolsky, because the defense doesn't read the portion that we say supports our position. I'm reading from the case. Thus, it could be argued that in the absence of a written request to preserve such evidence, as long as a plaintiff's claim is reasonably foreseeable, a formal request to preserve the evidence is not required in order for a plaintiff to be entitled to a jury instruction on spoliation. That's out of Osmolsky. Osmolsky then goes on and creates this limited exception for cases involving videotapes. This court's holding in Osmolsky was very specific. Quote, "We hold that if a defendant that has knowledge that an accident or incident has occurred on its property and the same defendant has a video camera," and it goes on to say, you know, preserve the video. So that, when there's a request to do so, that's a very specific holding in Osmolsky after this court acknowledges what the general rule is that there's a common law duty to preserve evidence when there's a reasonable anticipation of litigation. Let's look at Townsend, that they say is distinguishable. Again, I'm going to quote from this court's decision in Townsend. If BCBE destroyed evidence under factual circumstances that would make it liable for negligent destruction of evidence, this destruction occurred subsequent to the accident at a time when BCBE had a reasonable basis to understand that the broken railing was evidence that could be used in a legal proceeding. And keep in mind, this is the third-party context. This is the broken railing being used against the manufacturer in a product's liability action, which is just like our case. That's why we say Townsend is directly on point. If you look at Stimson versus Ford, I'm going to quote from that case because, again, this is the 5th District's interpretation of what the law is in Florida. Not our interpretation, the 5th District. They say that when they're talking about Ford's handling of the evidence, they then say, "See generally Palmas," and then this is their quote, "listing cases where a duty to preserve evidence is said to arise once a party knows of litigation or potential for litigation." Then they say, "See also Osmolsky and American Hospitality," which are the other cases that we rely on. So this is not what we're saying the law in Florida is. These are direct quotes from the cases themselves. The other point that I wanted to make is that it seems as though the arguments are morphing a little bit, and that what they said in their brief and what the trial court said in the underlying order is we're granting summary judgment in their favor because there's no common law duty to preserve evidence. The arguments here now, which I think we've clearly cleared that up, the case law supports that the duty exists. But now the arguments seem to be morphing into, well, what did we know? What did we not know? She didn't write a written request. If the issue is knowledge, there is clearly a question of fact. And whether there was a reasonable anticipation of litigation, that's a question of fact. So, and that holds true for the voluntary assumption as well. They like to talk about voluntary assumption and again say, well, she didn't write a written, the woman is in the hospital having her leg amputated. We are not talking about a case where the vehicle was destroyed 2 days before a 4-year statute of limitations expired, or the ridiculous case of 12 years on a statute of repose. The vehicle was destroyed 29 days after the accident as a result of Copart's negligence, and that's in the record. Even the defense own expert admits this type of injury doesn't occur in these types of accidents. Something else was going on here for this lady to have her leg amputated as a result of this type of accident. So their own adjuster says that as early as December 28th, they knew there would be litigation, because keep in mind, the plaintiff rejected the tender. I can't remember the exact amount of the policy limits, but it was a relatively low amount, maybe $10,000, $20,000. It was a low policy limits. So the tender was rejected before her leg was amputated. They knew about the amputation, and then they write a letter. They take possession of her vehicle. Then they write a letter saying, we've got possession of your vehicle, and by the way, as the judge pointed out, the letter says we're taking it to investigate it and evaluate it, but we're just supposed to ignore the fact that they take it actually for what's going for destruction, and it just happens to be destroyed by a fire in advance.
Counsel, thank you. You're at the end of your time.
Okay, and I'll just wrap up by saying that we think under either theory, voluntary assumption or common law duty, that the order should be reversed.
Thank you.